We're alive.
You're live. Good timing. This is the Senate Education Committee on behalf of April 17th. Doing a couple of quick bits of testimony from council members in a row on two different bills. But we're going to start with Representative first of all on page 650, the educational technology products. Can I say a few words about it? A couple of things. So the floor is yours.
Thank you. For the record, Angela Arsenault, representative from Williston, one of the co-lead sponsors on H650. And so definitely want to start by saying thank you. I did ask if I could add myself to the witness list. And I really appreciate having the opportunity to share a few thoughts with you all. So I want to, as they say, level set. I don't think I've ever said that, but we hear that a lot in committee. And just start out with the fact that, as you all know, this bill on the House side was a commerce bill, was in the Commerce Committee, very much a consumer protection bill, and that's how it was written. So just starting with that understanding, and backing up a little bit to, I think it was explained in the walkthrough, but to say that all business entities in Vermont are required to register with the Secretary of State's office. So this bill is using an existing legal framework and sort of regulatory framework and just applying it to education technology products for the purposes of consumer protection. The registry, therefore, is really a key to enforcement. We have to know and understand the universe of products and businesses operating in this space in order to enforce existing consumer protection laws, including Kids Code when applicable. But we have laws right now that are being violated by ed tech providers and the products that they provide. So the intent is to cast a wide net and would want to include AI products. There's no standard vetting procedure right now before these products are offered in schools and used by kids. So data privacy agreements can only cover so much, and they're not enforced, nor are they always followed. You heard testimony on Tuesday from VitaLearn, which is a Vermont-based group of school IT directors and personnel, that schools sometimes or often abandon software that schools thought would be effective and turns out to be ineffective. So I just want to pause here to really let in what that means. So they've taken schools of used products, allowed kids, encouraged, required in most cases, kids to use these products, thinking that they're going to be effective, safe, legal. Kids use the products, schools realize, oh, it's not really doing what we thought it was going to do. We can let it go. And this is how schools end up. Some schools are right now employing over 3,000 different apps and products.
This is apps we're basically speaking about here, correct? Just apps, or is it
mostly? I would say mostly apps. I think I use the term online and digital products. But we should also be taking a look at the hardware. So that would be the software side. The hardware side would be Chromebooks, iPads, the tools that students are using to access these apps should also be.
But the bill doesn't do that.
I would say not directly.
Because it's not an education bill.
Mm-hmm.
It doesn't sort of have a lot of connective tissue to the actual how school districts would implement. It doesn't have any, right? It's just a registry.
Right. It's really setting up the registry that happens outside of schools, and of course involves the Agency of Education. It makes sense for the agency to be the state entity that sets up these criteria. I realized I had a great conversation with the folks who were representing the agency on Tuesday, and I realized that I was saying standard, and they were understanding that as we talk about education quality standards. And I was like, oh no, we're talking about criteria for the products.
Age appropriate design code.
similar to age appropriate design code. Certainly it would, things like how they handle data, how they collect data, what they do with it, and design is certainly a part of it. So I can get to that quickly. I have some thoughts on that regarding the AOE testimony. But I want to just again keep us grounded in that consumer protection realm and think of another product that kids encounter every single day in school that is not subject to any safety regulations. Like from the chairs they sit on, the desks they use, the food they eat, obviously their drinking water, like things coming into schools are generally held to a standard.
We talked a lot about PCBs lately,
I know
and
you've been
that house
discussing-
canceling the PCB testing.
Yes. Completely separate topic, but
Really related.
yes. And look what we're doing to clean up the mess caused by PCBs and how expensive it is. We're creating a similar mess. And the really scary thing is it's in our kids' brains. What's the cost to clean that up? And what are we doing? How can we really be okay with that, knowing that these products are not vetted? So effectively, when you say we try these things out and then we abandon them if they don't work, that's saying that our kids are test subjects. This is not developmentally appropriate, nor is it in line with how we typically introduce products to a marketplace, especially where kids are involved. We need to move away from the presumption of use of these products and from allowing snazzy marketing and ubiquity to rule in education. That's what it's come to. I know that school and district-based folks believe that data privacy agreements are enough, and I believe that everyone involved in our schools is doing their very best. But tech companies are doing better, they're doing more, and they will always find a way to make money. This is a marketplace issue. There's an estimate, I think I just read, somewhere in upwards of $33 billion industry. I think currently the ed tech product market is booming. Our schools have become unregulated and target-rich marketplace environments for ed tech products, which have never been proven to be safe or effective in education, and are increasingly being found to violate various laws. Legal and safe should be the bare minimum, the very low bar. I hope you'll have a chance to hear from Andy Liddell. He's on the witness list from the EdTech Law Center, who can update you on various pending lawsuits that they've brought. They just received an encouraging ruling from the Ninth Circuit, making it very clear that schools do not have a legal right to stand in the shoes of parents when it comes to data privacy agreements. So all these agreements that are being signed with schools and products are actually legally invalid for the students who are using the products, because parents are not, even these blanket, every once a year you have to fill out all these forms in PowerSchool and other problematic products, and consent to your kids using various tech products. Those consent forms are actually not legally binding or correct. Oh, sorry.
Can we?
I'm not supposed to call on people.
Yeah,
That was such a neat
that's good.
description.
So the parents have a signature form at the beginning of the year for software, should be, there is anticipated to be used during the year, but that's not sufficient.
Right, it's anticipated to be used during the year and to apply to like almost everything that the kids will encounter.
Okay.
And that's not actually legal.
So what replaces it?
It would have to be individual consent between the parent and the product maker.
Okay.
So this ruling and Andy Liddell can certainly tell you so much more about it, but the ruling stands to really overhaul the landscape, because the schools have been working under this presumption, and this is not the first Google additional services. There was a lawsuit involving Google additional services. Schools had to come back. Even in Vermont, this happened a year and a half ago. Schools had to come back to parents and say, "Oops, we didn't realize we needed to ask you for specific permission for these products. Do you get permission, yes or no?" And the problem right now in Vermont, I happen to have 2 high schoolers, and they both go to different tech centers. So I fill out PowerSchool forms for 2 kids for 3 different schools, and the responses are different across the district. So some districts will say, do you consent to these additional services? And if you say no, they say, well, okay, but you should be aware that you might be basically impacting your child's education. Like, I'm sure it's Google language. And then if you say no in other districts, they're like, cool, we already banned YouTube on all district devices, so don't worry about it. So there's just a real range.
So if I could, we were saying this on software, yet if the school has decided this is a piece of literature, I want your children to read, and you as a parent say, I don't concur with this. Usually you don't get asked. It gets put in front of the child in the classroom. And you might not even know that you see this literature because, most parents you're going to school, happen to come home and see the book. It's like, wait a minute, I didn't want you reading that.
Right.
Nobody asked me. It's
Yeah,
kind of the same thing that the school said, well, I said it was okay.
But the lawsuit was about data privacy,
Yes, about data privacy agreements.
right?
If they're taking their data, I
Academic freedom.
100%
Yeah,
agree with, but it's like when you sign that form that it's no different when you send your child in saying, I agree to what.
I hear you.
Okay.
I hear you. I have a couple thoughts on that.
All right.
One is that the difference really is, as Senator Ramsden was saying, that you're consenting in the data situation, you're consenting to your child's information, personal information being used in whatever fashion the product or
Now, does
using
the
it.
child put in their information?
On many of the products, an account is required. On some products, it's not. So it may not be my child's name and, identify. It might even be anonymized data, but it's still data. So there's this AI product I believe it's called Amira. It's supposed to help with literacy. That product uses a child's voice to train its models. No parent has consented to their child's voice being used to train those AI models. Interestingly, in the case of literature, I believe there was a recent Supreme Court decision that said actually parents do have a right to opt their kids out of certain things. So,
So we're gonna get your difference between the two tech centers. When we make this policy, this is gonna make that consistent through all schools.
yes, that is the intent.
It kind of goes back to the original cell phone bill, which had an opt-out, a section in it that got taken out. Parents want to be able to opt out. If we pass this bill and we set the policy, we don't have to have that.
So I have a bill for that. If you're interested, H830 is an opt-out bill. This bill 650 really, again, focuses on what's happening before the products come into the school. So it's really setting up that gate, that system to say, in order for a school to even contemplate using a product, it has to meet these standards. And we're asking the AOE to tell us in this bill, we're saying, tell us what you would need to come up with that set of criteria. And because we have the registry, we would have at least a running start at understanding the universe of products.
How isn't the registry going to be a full-time job for regular people to keep up with?
Thankfully, no, we don't believe so. As I said, theoretically, these businesses are already registering. So what the Secretary of State's office, and of course, I imagine you'll hear from them, what the Secretary of State's office has agreed to do is create additional fields in the form that entities are already using. It's like picture a drop-down menu where they can say that they are providing ed tech products and then list the products. And then in that form, they would say they have to attest to following all applicable state and federal laws. So Kids Code, COPPA, so it's really just looping into the existing framework by adding a few fields.
So there won't be a view of every product, like open it, using it to make sure it's more attestation that it conforms.
And I know it has a lot of requirements for someone to confirm that they have certain policies and
Oh, you mean the
the AOE study.
But I think you were asking about the registry in particular with the Secretary of State's office.
Oh, because then
So that's just.
there's a vetting.
That's the registry.
Just the
Then
registry.
there's a report.
The registry is, I mean, I don't want to oversimplify it, but one way to think of it is, this is something these companies should already be doing. What the registry portion of 650 does is add a few boxes and fields that they have to figure
So
out.
I mean, I don't know if you were sitting here when I would like, does ChatGPT register the state,
Mhm.
right? They don't, they have like a canceled, OpenAI has a canceled thing with the state. I don't know what that means. But the really big problem I see with that piece is the bill says with or without a contract.
Mhm.
So if if your teacher says, I see you struggling with this, I want to talk to you and your parents about like Duolingo, ABC or whatever. I don't do Duolingo's registered either. Also because it's free.
Mhm.
So if you're Khan Academy or Duolingo or then something less reputable, if there's no contract, I don't think they register with the state.
That may be, but I'm not sure if they're following the law.
We should look at that area of law maybe and talk to
I think
DFR.
that the Secretary of State could help answer,
Yeah.
or the Secretary of State's office could help answer those questions. Because yes, right, there are already these requirements. We're really just trying to piggyback on the existing requirements.
Mhm.
And
I think if you looked at the Secretary of State's,
Yes.
database, you'd find a lot of companies that probably don't meet the definition of having a contract that has like a
but I
legally
think the
binding nexus with the
requirement
state.
is if you're doing business to the state.
But doing business, what does that mean? That
Yeah.
finance talks all about the nexus and DFR answers
So-
those questions.
Who did you have in from, Secretary of State?
David Hall and Lauren Hibbert.
Okay.
Yeah, and they've both been involved in conversations leading up to the session.
Should I put you? No, my colleague.
That if nothing else, just to have to register the software, hardware, the device, at least we would get it on the radar of that. This is something they want to incorporate. It's like Chromebook. They were in the schools and nobody knew about it. None of the parents, none of us.
Yeah, I mean, the hope is that, again, and I should, of course, I'll concede that like not every
Right.
company complies with the law. And that's part of the hope that with a registry, with that option or, to check that you are an ed tech provider, we get a better handle on the universe of products that are available, and that can help the Attorney General with enforcement. The enforcement goes through a different state entity altogether, but as you see in here, there's a requirement for the Secretary of State's office and the AOE to work with schools to identify products that have not registered. So we are trying to also capture those just by working with schools, saying like, what do you see on this list that you're using? Or what do you see that's not on this list that you're using?
So we have the registry in section 1.
Yep.
Then in section. More of section 2, then we have the review.
Yes.
And that's where I was focused on. Isn't that a part of the work? Not that that's bad, but just so we understand it.
Yep.
To actually do the review of all these products going through register.
So thank you so much for this question. The review is not a review of all the products once they're registered. It's a review of what it would take for the state of Vermont to establish a process through which we would determine
Okay.
the criteria.
And thus the report.
Yes, the report would not, the report that's asked for in this bill does not ask the AOE to actually vet the products.
Just
We're just setting up, it's like half steps.
asking them.
We're setting up the registry,
What would it take?
Yeah.
Yeah, okay.
and they may
So-
come back and say, this is too big a job.
Yeah.
There's no way we can capture everything. And maybe then we say, okay, but at least, right, there are that's why we actually have on page, we ask on page 4, which state entities should be involved in certification process and to what extent, and also, there's something about third party. So under, whether any on page 5, line 8, whether any third party services, including internet safety labs, should be utilized to assist in certification. So just thrown it out there to the AOE, like, we aren't expecting that you can do all of this. There are independent research labs that do this kind of work, and Jared Cooney Horvath, who I think hopefully will testify, he testified in Commerce that, you know, some states have the opportunity to partner with state colleges or universities, you know, where this type of work can be done. So it's just kind of, it's not even trying to set that up yet. It's just saying what would work for you all at the agency.
Senator Weeks.
Thanks, sir. So, why do we need to set up the registry in the section 1 efforts before we have the section 2 results?
I think that the registry is important to be established. Again, just to provide better, there's the word I'm looking for, I'm not saying visualization, but that's not what I mean. Well, so that we know how many products are we talking about, you know, like the information we get by having the registry would help inform, I think, the AOE's work on the report. And it will take a little bit of time for the Secretary of State's office to create this form in their system. So starting the process at the same time, I think the Secretary of State's timeline will still be a little bit ahead of the agency's timeline, and we've given them till, I think it was November 27th, the Agency of Education. So try to really build in enough time, knowing that this could be a big job, but after conversations, hearing their testimony and conversations in the hallway, it feels like they're moving in a similar direction already with what they were talking about with high quality instructional materials and things like that. So I think it will actually dovetail nicely. It's that's my optimistic hope.
I mean, in my conversations, you've talked about things that I just think are more aligned with design code and basic educational principles we might want to follow, like the cell phone ban. That there's probably just an age where we shouldn't be giving kids Chromebooks anymore. You know, we have to think about academic freedom at the high school level. We probably shouldn't have, we should look at what contracts even make sense for K-3 education, or just ban ed tech from K-3 education potentially. Yeah, so I just kind of feel like 2 years to make all these good actors and then maybe some shady actors register just doesn't get at what I think originally when we started with Chromebooks and digital things. I just learned not as younger than me, but you learned to type in 3rd grade on our computers, but they were a computer lab. Then we probably thought, oh, kids all need the same access to technology that other kids get at home, et cetera. So it's probably just an appropriate time to think about pedagogy related to screens and technology.
I 100% agree. Yes. And I still feel that this bill is necessary.
So that's a completely different topic.
I think you're absolutely right.
I personally don't think we have the bill that will get us there in the next 2 years while we're making a registry, potentially products that are obsolete 2 years from now.
Well, I think since I think it's an annual registry. So the products will still be around and they're proliferating like crazy right now. So I'm not too worried. I'm not too worried about them becoming obsolete. I think there is still, as we said with phone-free schools, that was an attempt at an upstream measure, but we need to go even further upstream. And I keep thinking of the Swiss cheese approach. This is a multi-layer mitigation situation, and so this is just another layer. I think you're absolutely right that we should be looking, and that would be the work of this committee, not the policy committee,
right?
To dig in deep as far as what is the appropriate age for a one-to-one program. Why are we handing out iPads in kindergarten?
And so once the Secretary of State does the work and gets the form set up, it's really on the producer anyway.
Yeah.
Just to get to register. So
yeah,
those people are okay.
Yeah, exactly.
So
I did. I have two actually. They're short.
Thank you.
We took some testimony about a SDPA system within, I think that relates to privacy.
Yep.
How is this? What's the kind of cross pollination between what you're proposing and that system, and how are they different?
Yeah, that's the Student Data Privacy Consortium, I think, and the SDPA, Student Data Privacy Agreements, that are largely, so, and the AOE testified that most Vermont schools are part of that consortium. It is about 2/3 of schools are, 1/3 are not. And I really appreciate that the AOE in their written testimony, said that they would entertain, and maybe this is something to work into, amendment to work into the bill, that they would be okay with requiring all Vermont supervisory unions and districts to participate in the Vermont Student Data Privacy Alliance, which is to get to those SDPAs. So the good thing about that, as they mentioned, is that those data privacy agreements are negotiated with more stakeholders, and so they feel they have more leverage. It brings me back, however, to the fact that student data privacy agreements are still not enough. They're violated all the time by these companies, and there's no enforcement against them, or very little enforcement against the violation. And I think that we're still going at it wrong if all we're worried about is data privacy, and we're not asking the questions that Ron Hinsdale is bringing up, and that a lot of educators are bringing up now, which is, should we be using these products at all? If we're going to, data privacy is incredibly important, but so is efficacy, and that's not contemplated at all in a privacy agreement. And I worry that the privacy agreements that are negotiated are still impacted by industry. They're impacted by the tech companies, because even the national handout, with the logos of all that I think you brought in, Terry, the Vermont Coalition created, shows some of the entanglements. It's another case of asking the regulated to help with the regulation. A lot of those agreements are arrived at with help from the companies you're trying to regulate, and they are serving their interests in those agreements.
Okay. So all this boils down to what's the educational benefit to the student, what's the right timing and such. Who do you trust to be the adjudicator of those decisions? Is it AOE or?
We're asking the AOE to ultimately be the
That will come out of the report.
Yeah. Good. Yeah, that's the intent for sure.
Okay, we need to move on.
I just want to suggest that we hear from Agency of Digital Services, because they have the most tech savvy experts on all of these questions. They have groups set up on AI and
We'll say ed tech is something quite unique, and so it will be important to hear from ed tech specialists as well. So if I can just add really quickly, the Vermont Agency of Education, in their testimony here, I really appreciate, we have come a long way together, and I really want to appreciate that. And again, notice that there is alignment, and I think it's great that they're willing to have a lot of this language reflected in statute. But what they've offered here, it doesn't get us as far as we need to go. And I think 650 helps get us further along the path, and still understanding there will continue to be work to be done. Yes. But we can't, they're talking about these two tracks, data privacy and educational efficacy. And they want to separate it out. I really encourage us to keep those together. I think that those two ideas, effectiveness, cannot be completely divorced from data privacy practices, because we need to know what the data privacy practices are to help determine the efficacy, the effectiveness. Like if our kids are just being used as like data farms, I don't care how solid the product is. It should not matter. So I really thank you for your time and for taking this bill up.
No, I think it can wait. I mean, at some point, somebody's gonna have to follow what they need to do this. With benefiting financially from all of this.
It's big tech. It's big tech. And I can send a really great article that was just published this week about the entanglements even within people move from like the upper echelons of the Department of Education into ed tech companies, and then there's this
I mean,
cycling
even
through.
politicians.
Yeah,
That's the way it goes.
that is life, but we're talking.
Military happens everywhere.
It's true. It's true. I just think, anytime we're talking about kids and their brains and their future, because what Google has done, and this is one more thing, this is in millions of pages of discovery documents came out during the social media trials that happened recently. And these are social media trials, but you would be amazed at how often the documents reference schools and how often companies like Google, especially because of YouTube and even Meta because of Instagram, they are targeting schools. It's intentional. It's by design. They're trying to, you put a Chromebook in a kid's hand when that child is 8 years old. And according to Google, they've got a client for life. They've got a customer for life. And they're going to track that kid from the time they're 8 years old. They're going to know all of that child's patterns, habits, likes, and dislikes, and they're going to market to that kid. So it's happening in schools. That's what's just beyond the pale. Those schools should not be a marketplace.
Question, have you given your child a tablet or anything to use?
The school certainly do.
About the school, I'm asking you as a parent,
Yes.
have you given your kid any
My
tablet or
teenagers,
anything to play with?
My daughter, my mother, so she lives near us. So for her 3rd birthday, my mother gave my daughter her old tablet to color with. And she was like, "Are you okay with this?" I'm like, "She can't be on the internet with it. Like, that would be a problem."
But they
Very
still, it's.
Oh, yeah.
No,
Maybe
So
you
I-
think she's the 7-year-old woman, but yeah.
I just,
So, we've got circuit trustees on this. So.
Yeah.
Next up, it's 50 years.
Want to stay and listen, but
You have to, absenteeism. Thanks.
Nice weekend.
So, Representative Chapin.
Thanks for having me. Ella Chapin, for the record, representative from East Montpelier, and I sit on the Environment Committee. I am here to share a personal story related to your chronic absenteeism bill. I'll just start by saying
Actually, let's just set it up a little bit. Page 6. This relates to page 6. It's not.
yes, you would take a minute to sort of switch over to
Sure.
page 930.
Page 6. It really lines like 3 through 6, somewhere in that.
Yeah.
page 6, 3 through 6.
It was a floor amendment.
I offered a floor amendment that shows up in
And
your
you're going to
bill.
explain why you offered that amendment.
I am, and with a bit of what I think will be a cautionary tale as you move forward with this bill, not around the bill entirely. I fully support addressing and moving towards a preventative approach for chronic absenteeism. I am concerned about the implications and how they would have affected my family for a top-down AOE sort of mandatory policy that all schools would have to adopt, and the potential unintended consequences based on what could be in that policy. And so I'll explain why. And just did you say sorry, the bill in front of?
Oh, you can take mine.
I just want to tell you which lines it's on. Did you say which line?
He was starting here, it says
Yes.
how to address
It's about
absenteeism.
students with
And this
disabilities.
hazing harassment comes in here.
Yeah.
And just to clean this out entirely, set this up entirely.
Oh, not as bad.
This, you put this in as a floor amendment. The agency has requested that we take it out. And now,
And the floor amendment, how it's in your bill, it was offered as floor amendment. And it's related to people with disabilities, which obviously is covered well as under federal law. But let me tell you my story and where I'm coming from, and think about how you might address this in the bill. So yeah, it's like a sentence or two at the top of page 6 about how the policy would address students with disabilities.
Which Which now is it as passed by the House?
That's passed by House, page 6.
And it starts out Vermont School Council Association?
Yeah.
It's a long sentence.
Yeah,
Just
and
say that.
the part that got added in. It's after the Commonwealth on line 2.
Yeah.
And then on line 3, it starts with which shall include specific.
Okay.
So when I saw the bill on the
That's,
notice
that's what we're
calendar,
talking about.
All
I
right.
saw the bill on the notice calendar, I immediately was concerned about how this kind of policy could affect my child. And so I'm really just gonna tell you a little bit about my child. So I have a 15-year-old, he's 15 now, he's in 9th grade, 32. And, we learned 2 years ago that he had a disability, a developmental disability, that's fairly unusual. And I'd rather not share the diagnosis on record, but I'd be happy to explain it in more detail if anybody's curious at another time. So I would describe it as a nervous system disability where the more pressure or expectation or sort of top down, anything that sort of threatens his autonomy is perceived in his amygdala as a threat. And it makes it hard for him to do things. So it's a, all growing up, he didn't really want to go to school and we struggled to get him to go to school, even though he seemed to have fun at school and he seemed to do well in school. When we asked why he didn't want to go to school, he didn't really have an answer because particularly what the problem was. And now we understand that just school is a challenging environment for him. And the more he spends time in those kind of triggering environments, the more his nervous system goes into sort of override and he goes into that amygdala fight, flight, freeze space. And some children who have this diagnosis, if they go more into the fight side, they get identified really young, 4, 5, 6 years old, because they're fighting or screaming and acting out. My child is a freeze child, so he goes into sort of shutdown and quiet and withdraws. And so we didn't get this diagnosis until he was 13. And I've met a lot of parents with similar experiences. And school's just a really triggering environment. A lot of kids have the same diagnosis, and my child just don't go to school. After 4th grade, he couldn't go back to school and just said during the summer, I can't do it. I want to unschool. He had read an article about unschooling in a parenting magazine that I had. And we laughed and we were like, well, of course, every child wants to unschool or not go to school. But like, at the time we laughed it off. But I did end up homeschooling him for 5th grade. He went part-time to a really tiny private school for 6th grade. And then we got him sort of back into public school in 7th grade, 8th grade. And during the year of 7th grade, he was incredibly depressed. It was a very scary time for our family. He went to school 2 to 3 days a week during 7th grade. And in the middle of the year, we got the diagnosis. We were getting letters from the state, you're not complying, your child's been in school enough, he's already missed 20 days, at that like November mark or something. And our school nurse, we were trying to figure out what was going on at the time. And we got the diagnosis in January. We had a school nurse who sort of identified that this was like a major mental health, at least, issue. And
Can I pause you there?
yes,
Do you feel like another family might not have gotten the same attention? Like you were probably showing up and saying, we know, and we're struggling.
and that is part of my story to you and my cautionary tale is that while we got a diagnosis that's protected under federal law, a lot of people don't. And a lot of people suffer through, like we did for years, trying to figure out what's going on with their child, either not finding the resources because we just couldn't figure it out, or some people don't have the resources to get there.
Did the materials that you got that said your child is truant offer any help? Like, did they point you to the places you should go to get support?
And the school really didn't have a lot of things. It really was our outside of school therapeutic support that ended up being like, I think your child's neurodivergent, you should get an assessment. And we also went for an outside of assessment because when I talked to some parents who had similar really challenging things going on to their kids, they suggested an external, was costly, not fully covered by insurance and not covered by the school district assessment, but it gave us a very detailed kind of like.
How long did it take to get a diagnosis from the time you said, hey, you should go see a doctor to this is what's called
6 months.
6 months.
It took a couple months to get, it took once I called the evaluator to get an appointment. It took about 3 months to get the appointment, and actually they were able to fit us in because of cancellation. At the time, this was shortly after the pandemic, this is like 3 years ago, so a lot of backup in this field. So a lot of people were waiting well over a year. In fact, if I had tried to get a local, more publicly accessible one, they were scheduling out well over a year and a half.
Wow.
At the time, it's what I would call. So, and then it takes like the evaluation took about 2.5 months. It's a period of appointments and interviews and testing. And then, so really what I want to say is in that in our most challenging time when my child was in crisis and not able to go to school routinely at all. My child also has a really high IQ and this diagnosis is he tries to meet everybody in the world, even though he's triggered by everyone's expectations of him, he's also tries to meet them. So he performs fine at school, even when he only goes to school 2 or 3 days a week. So luckily for us, he wasn't suffering academically other than not thriving. He wasn't falling, he wasn't struggling to pass his classes. But I will just want to explain that during that time, and especially once we had the diagnosis and a letter from a therapist that explained why the diagnosis was triggered by pressure to show up at school, the sort of special educator and administration once I sort of engaged the administrative level at our school about the truancy issues, and we had a really good explanation and argument for why nobody should be pressuring our child to go to school right now. They had the flexibility to say, we know you're going to keep getting these letters from the state. We are not going to put any pressure on your child to be in school. We're not going to call them into the office to talk about it. We're not going to call you and talk about it. We'd love periodic updates on how he's doing, but or if he's going to be out for an extended period of time, I'd like you to let us know. But I can't predict when my child's going to not be able to go to school. So he really went. So that whole year, and in the middle of it, we got that help. We had that conversation with the school, and that year, really, he ended up in hospital by the end of the year. So, but he passed 7th grade, and we were putting significant supports in place at home, such that by the time we started 8th grade, he was on the up and up, and he was actually that fall, he was no longer depressed. And really coming out of the depression part, there's the depression part and the developmental disability part. And we were, focusing on accommodating for the developmental disability, which is the thing that relieved depression. 8th grade, he missed about 27 to 30% of school days. And that was just last school year. This year, and again, we had the same conversations and the school continued. So they were like, and we were developing a 504 last year also. And in that process, we built into the 504 plan that truancy issues should basically not be addressed unless something changes and he's not doing well enough in his classes or parents have a concern. And this year, he is basically, unless he's literally got a virus, he has been in school every single day. And I just want to share that the discretion that the leadership of our school had to support us and really learn, because they had never heard of this diagnosis. It's within the autism spectrum, but it's like the diagnosis he has in other countries is actually a separate DSM, so it's not considered autism. So it's a very narrow developmental disability.
Did you know if AOE had heard of this disability?
I never engaged with AOE or heard that but not the one. Yeah, I have no knowledge of.
That's part of the system. AOE is doing what we told them to do. It's policy. So, there's got to be that discretion down to the school level. A lot of schools, to meet their school budgets, they got rid of interventions that maybe could have worked with the family and found that, got them to some help to get that diagnosed sooner. And that's part of the problem. We can't afford, we can't get our budget passed. So they start cutting programs at what cost? So I'm kind of inclined to say that AOE did what what they could, what they had to. But the school said, we're gonna work.
Yeah.
It's gotta be discretionary.
And that's the only thing I'm advocating for here today, is that you just careful about any policy that's required, that every school adopt a similar or stronger policy. And I know the policy is aimed at prevention, and we're kind of move away from just this punitive approach. But I guess I'm just really concerned about a sort of top-down policy model that could, for some schools, could feel like it's a loss of that discussion. That's really all I wanted to share.
That's, yeah. I got it. Yeah.
I mean, there's two threads to this, right? Because it was my state's attorney at first who came to me and said we should fix this kind of issue.
Yeah.
Did you have any kind of scary or criminal feeling interaction with the state's attorney because the school said this is okay? Was the state's attorney completely relieved to not pursue this?
I have no idea. This someone within our school administration basically said it's that what would happen is that the state would potentially come to the school and say, we want to enforce this. And then the school would have an opportunity to say, we do or don't.
Okay.
Sort of support, or we. Like that's a really unclear area.
It is unclear. That's kind of why
Um,
it's like different in every county. If the state's attorney is telling you to solve this or this.
yeah. And so, I just felt lucky.
Yeah.
I didn't feel protected
Yeah.
in that situation.
Right.
There again, you're a very good parent by the sounds, and that has a lot to do with it.
Yeah,
And there's a
I'm
lot
worried
of-
about all the students who don't have the attention or support or resource,
Or their parent isn't deemed a very good parent, even
Yes.
if they're doing their best.
Thanks, that's all.
Great.
Yeah.
Thank you all.
Thank you.
Have a good weekend.
You too.
So we were gonna spend a little time doing, the committee, what you want to do with that. We have Bethlehem for the next hour and a half. I had thought that we might do a sort of line by line, each 9:30 and see how close we are to moving this. But on the other hand, we have to. We're not talking about a little bit. No, something with this one. UCD to this, right? So if you want to do that, or if you want to go straight to it's 9:55 walkthrough.
You're going to issue.
No, I'm getting it. I mean, we got to do both. And what's on what's
I feel like 9:55 is probably the priority of things that we should be doing. I don't know if there's much disagreement on issues at 9:30 that we wouldn't be able to do it particularly fast. Not saying rush, but next week. But that's fine.
so that cuts both ways. They're not too much. Okay. Let's just move to 9:55 then today, and we'll come back. We'll find a time to do the line by line with 9:30 again with an eye toward trying to get this. I'm thinking, by the way, that we 9:30 so we can get out here next week. Okay. So my understanding, Beth, and they'll tell us this, is that we actually don't have a complete as passed yet,
No.
but we have, in a way, we still have it in these two sections, 1 through 45. And
So
then the second
Beth St.
part.
James, Office of Legislative Counsel. So in order to look at all of what passed the House this morning, we'll need the as introduced by, the Ways and Means Amendment, and then a floor amendment offered by Representatives Kornheiser and Kimball. You should have all three.
Yes.
And then as I was sitting here, I remembered that we have a timeline as well. So Daphne has posted that. I sent that to her while I was sitting here. But the timeline doesn't really make much sense unless we walk through the bill, at least detail wise. So I would take your lead on where you want to start.
Well, I think with the ed committees, that's the first part of the bill, right?
Mhm.
Logically. We want to do 45.
And before we start 9:55, can I just ask, do you have changes that you know you want to make to H 9:30 that I could get going on?
That's why I was thinking of doing it. Um, Does anybody have in their mind anything in particular on, the question really for us is going to be whether we accept that the agencies, the things that they wanted us to do, or whether we don't.
I was gonna propose that homeschool change, putting in that language back.
So go ahead.
From the miscellaneous bill that never went anywhere?
Yes, that one.
Yeah. I
So
think
you'd like to take out the study or the report back related to homeschool?
Yeah.
And put in the language from, I want to say it was S-166, maybe?
I think it was
It was a miscellaneous, but I know what you're talking
Yeah.
about. That's more oversight.
that was the hearings after enrollment.
Yes.
That we, yes, that's.
Yeah. Is that what you would like to see for a draft?
yes.
Okay.
Yeah.
Any other changes?
I liked all of the changes that were brought to us by the restorative experts.
Did they bring that to us and,
You know, they all were very specific about excused versus unexcused and
did they give us that in writing?
yeah. I mean, they gave it to us in their testimony. I don't know if someone, I don't know what. they've done.
Yeah, so I'm only asking, unless we want to go line by line and you
Yeah.
give me instruction, I don't think I feel comfortable reviewing testimony and making decisions on my own.
Just to the levels.
Okay.
So for now.
So then should I propose those?
If you have them specifically,
I
not now, we'll do it.
Okay.
We'll do it.
like sweet. Okay, if you want to move it, I will take that as a cue to propose an amendment
right.
based on what we heard.
Okay. So, and I think we wanted today, our goal for today is just to understand what's there. And not have real face off of a discussion, just understand it, then we'll have, try to do high level, just so we know what's in there.
Okay, so,
Next week, you anticipate, your Representative Conlon coming in and kind of giving his explanation of why.
We always do it works in this committee. Yeah, so yes, yeah, we used to hear, no, that was a joke. We always do the one. We have,
Right.
we have Ben doing the walk and then Bill sponsor, but yeah, we'll do that.
so when are you, I have on my calendar, booked till 3:30. Is that when you anticipate wrapping up for the day? Okay.
So we'll just get as far as we get.
Okay, so do you want me to go in great detail or just kind of talk more generally?
Kind of talk generally,
Okay.
and flip through the bill.
Okay.
Yeah, you don't have to go into great
Okay.
detail.
And I hope that this is clear, but I'm only responsible for like a third of the bill. Okay. So I can't speak to the finance.
And that third would be the first 45 pages that we have here separately.
Yes, again, but I also have a big chunk of the Ways and Means
Okay,
Amendment as
all right.
well.
Okay.
Okay.
But you're gonna start by helping us understand.
We're gonna-
This isn't a strike all.
In fact, I am going to be proposing to you all that you don't do a strike all either.
Okay.
We'll see. Okay. Okay. So H 955 as introduced, this was a committee bill. So the House Education report is not a report, it's actually the bill itself. It starts with some legislative intent. Subsection A is taken directly from Act 73. In the interest of time, I'm just going to let the language speak for itself. Subsection B is new. Do you want to focus on legislative intent or go into substantive sections?
Let's go into the substance.
Okay. So I think reader assistance headings are extremely helpful in this bill. There's a lot of different concepts. So we're in the cooperative educational service area section. So I think I mentioned this when we walked through the miscellaneous bill, that there were about 12 sections that were taken out of the miscellaneous bill by the Ways and Means Amendment. And that was the change from BOCES to CSAW. And that is what you're seeing in large part, there's substantive changes too that we're gonna go over. But most of what is in, most meaning, page numbers. The bulk of the language under this reader assistance heading is just the word change or the term change from boards of cooperative educational service areas to cooperative educational service areas, BOCES to CSUS. So I'm just gonna skip over when the only change is that language change. I'm not gonna reference it. There were several substantive amendments made though under this reader assistance heading. So section 2 on page 2, line 13 is an amendment to chapter 10 in the entire chapter in Title 16, which is currently your BOCES chapter. This language would change it to your CSAW chapter. It starts with the policy section, and the policy, I would say, has not changed necessarily. You'll see lots of strikeouts there. But the big change in section 2 is that so under current law, BOCES are formed voluntarily. Supervisory unions get together, they decide to form a cooperative. The big substantive change in section 2 is that no longer is it a voluntary process. Chapter 10, section 2 has now put every school district in the state or supervisory union in the state into a seesaw and created those seesaw memberships in statute. So that means anywhere there was language that made it seem like it was a voluntary process, I had to kind of tweak the language a little bit to make it not a voluntary process. So
Being that this is a lot of words, do they associate a map in this section to
we haven't gotten there yet. Are you asking me to speed up?
I'm not. Okay. I have a question about the definition.
answer the duration?
So all that to say that I wouldn't suggest that the policy was changed substantively here. It was reworded to reflect the fact that there's no longer a voluntary process. Definitions, jumping to page 3, section 602. No change to the definitions other than the language section or the language change, but they did add a definition here, and that is to define the term cooperative educational service area. It means an association of supervisory unions created pursuant to this chapter to deliver shared programs and services to complement the educational programs of member SUs in a cost-effective manner. A seesaw shall be a body politic and corporate with the powers and duties afforded it under this chapter.
This is where I feel like the whole question I have about the bill is, what is a seesaw and what makes it special or different than other entities? And does this definition encapsulate that?
It is a definition. Whether it encapsulates the rest of the enabling law, I think would be a policy opinion for you all.
Okay.
A seesaw is just what it says. It's a cooperative. It is not a government. It's not a government unit.
Okay,
It's not
so
a
the
unit
body
of governance.
politic and corporate.
It is a state created body, right? So in the same way that supervisory unions aren't governance units, right? They're not municipalities. There's no school district governance within.
There's no
supervisory.
board.
There is. We haven't gotten there yet.
Okay, so these have a board, their own board.
They are BOCES.
So this just takes the definition of a BOCES and makes it a
seesaw.
required.
Tomato,
Correct.
Okay,
That's it.
I can move on from the definition.
Senator Woods.
I'm not familiar with the body politic.
Yes, that is language that we commonly use when we're creating these quasi-political entities within the state that aren't like a branch of state government, but they aren't a private entity. And you'll see throughout, most of the questions that you've asked thus far have been great questions, but they all come back to the current law of BOCES. And so BOCES, all of their employees or public employees were eligible for retirement benefits, for collective bargaining, for teachers' health care, all of that. And there's language in current law. And this bill doesn't change any of that other than instead of BOCES now it's CISA. Can I still ask one more question?
I don't want you to hurry up.
Did BOCES have an unelected board?
BOCES, nope, we haven't gotten there yet.
Okay.
There is a statute that is in this bill that has not been changed other than that name change. That spells out the board for BOCES.
Mm-hmm.
The board for BOCES is made up of one person appointed by the supervisory union board. And it should be either a supervisory union board member or the superintendent or designate.
And BOCES had that.
Yes. That's been law for 2 years, 2 or 3 years. Yep.
Okay.
We only have.
So-
one area to take it.
We're just requiring that they form this board now. It's
You
you
are
are forming it. We are forming it.
Yep.
But we're still letting them decide
Who's on the board? Yep.
with you still.
Yep. So section 603, you can see all this strike through, right? This is the language that spelled out how supervisory unions would voluntarily get together and form a BOCES. But we're taking that off the table now. And we're jumping down on page 4 to line 15. And we're just saying that SUs are arranged into the following cooperative educational service areas. And then there are 7 BOCES created. And then each of the 7, so if we're using as an example, the first one, the Champlain Valley North CISA. Under that,
They haven't given us maps for that yet, right?
There was that.
Is in, I think.
I don't make the maps. I believe there is a map.
I don't know what's that, but anyway, that. I don't know how old that, was, but anyway, so.
Something
you
like,
have-
something close.
Probably. But so you have listed the 7, which districts are within the 7?
Yeah, so it's
Yeah.
the supervisory unions are members. And then I have put in here who the member school districts are of each supervisory union.
Can I ask one more? That they don't put the CTEs into this list anywhere?
The standalone school districts,
Yeah.
standalone CTE districts, no. They, no.
Does that matter?
Supervise, so that's a policy.
Okay.
CSAs and BOCES,
Mm-hmm.
the membership level is the supervisory union. And so those standalone CTE centers are not supervisory unions.
What can we write a policy to say they can be in it?
Sure. Sure.
Do whatever you want.
I'm trying to think through the policy implications of that. But perhaps that's not productive for our walk.
No.
No, it is.
But I'm gonna spend the weekend
Just
thinking
a
through the
question.
policy implications of leaving them out, which are also large.
Big advantage of services from.
I think in the interest of time, I would suggest we skip over the
Yes.
membership piece.
Yes.
And there are maps. And I think if you contacted the House Education Committee, they would get you those current maps. The one piece I want to point out is, find it here, on page 7, this is important for the rest of the bill. On page 7, line 3, number 5, the Vermont Learning Collaborative is your one existing BOCES right now. So they formed voluntarily and they are up and running, and they have been for a little while now.
And that's Woodstock and Oregon, correct?
It's like, wait, oh,
We spoke to her yesterday.
two rivers.
I'm just looking at the names of the supervisory unions. Yep. All of the rest of the BOCES, there are 7 BOCES, the rest of the BOCES keep supervisory unions intact, meaning the supervisory unions are not split between different CSAs. And because school districts do not straddle different supervisory unions, it also keeps school districts intact. But in order for this bill, this bill relies on the Vermont Learning Collaborative to perform some duties later on in the bill. And so in order to keep them an entity that can hit the ground running, right, that's already up and operational, H 955 is passed by the House, keeps the Vermont Learning Collaborative membership as it exists today, which means I think there are some, let's see. The map would be really helpful here. I guess I'll just note that the membership of the Vermont Learning Collaborative is their current membership. And so then we can jump to page 10, line 20. Current law requires the operating agreement for a voluntarily formed BOCES to be articles of agreement, which by definition, that term agreement kind of contemplates a meeting of the minds. But we are creating these groups in statute now, and so we're gonna just relabel that governing document bylaws. And so there's no longer any requirement for the secretary to approve the articles of agreement or anything like that. We're just asking each CSAW that you all, or the H 955 as passed by the House is established, to come up with their own operating agreement, and then largely keeps current law for what needs to be in there. The substantive changes on what needs to be in bylaws on page 12. No longer does there need to be anything in there related to method of termination of BOCES or withdrawal, because you can put their membership in statute, so they can't just decide to withdraw. And then the procedure for admitting new members. Again, you can put their membership in statute, so they can't just decide to change those. Can I ask something?
Okay, maybe we're getting to it. There's two things that I think would be spelled out more in a supervisory union. Number one is proportional representation. Is there anything about proportional representation?
No, we have not gotten to the board members yet.
Okay, but that is something about representation and how the budgets are voted on for a CISA.
We have not gotten to that yet.
Okay.
And it's all current law.
Okay.
They don't make any changes. So board of directors is right on the same page 12, subsection C. You can see the only change here to current law is that BOCES to CSAW change.
So what that means is there's not a representation requirement.
There is no proportional representation requirement in current law, and this bill does not change that.
So you can ask the Vermont Learning Collaborative how that goes actually.
Subsection D on line 13 has been struck because this was limiting the number of supervisory unions statewide, and now you are creating them in statute. On page 13, line 11, section 604, hours of CSAWs. H 955 is passed by the House, does two things to this section. One, on lines 16 and 17, it adds some examples of services that a CSAW may provide, including professional development, curriculum coordination and development, and transportation. That's a may. Right now, current law, you can see because it's not structured, just says get together, decide what programs you want to offer that best serve the needs of your members. So on lines 16 and 17, we're saying, and here are some examples of that. Lines 20 and 21 on the bottom of page 13 requires CSAWs to offer these services to its members. And on page 14, it's special education, including implementation and maintenance of tiered systems of support and the provision of low incidence, high cost services, business and administrative services, and union school district creation, consultation, and facilitation. So H 955 is passed by the House, requires CSAS to offer these services, but it does not require members to actually use these services.
So they might go through all this work to get the services up and running. And the district can say, "Nah, don't use that." That's what you're saying.
Yes.
Can I ask a question about, I know this doesn't change how they currently work. But are there any entities brought to the table that aren't school providing, that are non-operating districts? Are the non-operating districts
Yes.
at the table?
Oh, yes.
Okay, so they have a member.
They're part of every school district
Okay.
supervisory union has been assigned to a CSAW,
Okay,
regardless of their operating structure.
okay.
They're signed, but they don't have to work with them if they don't want.
Part of the nuance here is that the responsibility and statute for some of these services lives with supervisory unions or school districts. And the purpose behind, I understand that this is, the purpose behind the goal of the TISA is just that, is a cooperative to supplement services. Whether that's a good idea or a bad idea is a policy choice.
But there's nothing binding about it.
Well, now everyone has to be a member of one.
Okay,
But there's nothing that there's nothing that requires on a regular ongoing basis anyone to take advantage of the services that are available to them and offered by CISA. Half of this bill, as introduced section, does require some participation in something, and we will get there. But like, if you're just thinking about 10 years from now and you haven't made any legal changes to this language, you'd have to be a member of the CISA, but there's nothing requiring you to use their services. And then that was the last substantive change to the BOCES language, the CISA language. Everything else under this reader assistance heading is just changing the, there's one exception that we'll get to in a second, but everything else is just changing the BOCES to CISA. So we're gonna skip. So all of this remains current law related to the annual report, finances, public information, the employment sections, all remain current law. We're gonna skip to page 19.
Can I just ask, where's the section that alleviates them from using the services, makes it optional?
It's not, it doesn't explicitly state you don't have to use these services. It's on page 13, line 20. It says that a CISA shall offer the services.
I was gonna say, or line, they don't use it. Or, yeah, or
can I? Nice. I would have thought by now we would have seen a section that requires all of the member, that has like some requirements of all of the members of this CISA, such as providing reporting in the same way.
I skipped over those because there were no substantive changes in
Okay.
current law.
So it went from voluntary to required, but even in the voluntary process, you're supposed to the best of your ability provide all the school data and financial data of your supervisory union to the CISA.
No,
How do they do their work then?
it depends on what work they're offering. In the interest of time, I'm wondering if I mean, this is all at your direction, but there seem to be a lot of questions around current law and how BOCES work. Have you had anyone from a national organization or our current BOCES in to kind of lay that groundwork for you? Okay.
We had the one BOCES in.
Yeah, we did. That's right. So why?
But you-
That's not.
But I
There's
guess-
a savings in that.
I guess for me, I'm trying to make sure I understand, if a CISA is not voluntary,
Mhm.
it also has to commit, we're asking it to commit to some cooperative. We're asking it to be cooperative. Right, which like isn't spelled out, right? Like, what does it mean to be cooperative?
I think that is an interesting question. That is inherent in its name.
I guess not if it's required, right?
So I guess I don't understand your question.
Well, just that we are not defining what it means to say, you are now part of this cooperative and this is what you have to do to cooperate.
Would you like to walk through current law?
If there's no requirement to share data, that's one of my first questions about cooperation.
I don't know what you mean about shared data. So the seesaw exists, or the BOCES exists to serve the member districts or supervisory unions. So if as part of that existence, right, current law, let's look at page 13, lines 13 through 15. They have the power to provide educational programs, services, facilities, and professional and other staff that in its discretion best serves the needs of its members. So the seesaws, other than the new required services, right? And this is not a change in, these are not LEAs, right? These are not local education agencies that's defined under federal laws, right? So they're not entitled to special education funding. They are to provide special education services that at their discretion best serve the needs of their members. And I think the BOCES that we have up and running, and there are national organizations related to education cooperatives, could come in and explain to you how those decisions are made, right? Like that, how that discretion is exercised. And then I think the inherent in well, I feel like you're asking me to justify their existence, and I feel uncomfortable with that.
That's a great way of distilling what I am trying to say. They have the power to do a lot, but they don't have the power to compel the districts to do anything.
I don't know that I can agree with that.
Okay, I'm trying to figure out where the districts are compelled to do anything.
I think it'd be wise to have the BOCES that is already existing to see how that works.
Right. I feel like much of what you're asking is how a BOCES operates. And I am just the black and white law person. I am not the take these words and then execute it, right?
Right. It says they shall have the power to do all these nice things for the group. But I don't see anywhere where they have the authority. And if they're not voluntary.
They work, well, yeah, I did that part, but they work for the supervisory unions. And they do what the supervisory unions ask them to do. It's shared services for what the supervisory unions.
So thereby, in my mind, it remains voluntary.
In a way it does, because there's a few things they must offer. You are put in one. So that's not voluntary. Under that's
Yeah.
By the way, it's a whole other discussion. I put in one. It has a few things that it's required to do that you must allow it to do. Otherwise, the FGUs that participate within it decide what they want it to do.
Right. So
It's a way to gain, at least in theory, some scale beyond the current.
but it's all voluntary.
Almost. There's a little the exception with the part that lays out a few things they must do.
But they must offer it.
Yeah, that's true. You know,
Right. And as you could say,
Yeah, but you're probably going to want to. Well, anyway, I'm not. But
I'm just trying to understand the difference.
Yeah.
A supervisory union is non-optional. A CISA is optional. There's lines around this one.
Can I make an argument?
yeah,
Can we look at it like at a high level?
that's what we're.
Let's stick a pin in
That's what
this,
I'm trying to.
stick a pin in this, and I really like to go home and read the bill. I will do that. I've never read it, so I can ask questions rather than coming on See.
Yeah, we want to, let's make sure we give ourselves time to get through these 5 pages, so. Okay, let's keep going.
Do you want me to go over current law or do you want me to skip to the changes that are in the bill?
I just think go to the changes.
So we're gonna move to page 19, section 3. We're still in the Seesaw reader assistance heading. Page 19, line 3, section 3 repeals a piece of session law from Act 168, which created BOCES, which required a kind of status report from the Agency of Education on how many BOCES had been formed, and that's a moot point if you are creating them in statute. And then section 4 amends these what was formerly the BOCES Startup Grant Program. I'm on page 19, line 7. This grant program still exists. And current law is that if folks got together and decided to voluntarily form a BOCES, they could apply to the Agency of Education for up to $10,000 for startup costs to do the work to form a BOCES. Because there's no longer, they're no longer voluntarily getting together, we have to make some language changes here. And so we're referring to it as startup costs, and we're also increasing the amount of money from a $10,000 grant to a $15,000 grant. And the first instance of amendment in the Ways and Means Amendment is a change to this section. And so what Ways and Means did to subsection C, with the appropriation for this.
Okay.
I'm on a different document now.
Oh.
I'm on the Ways and Means Amendment.
Just that's
Single page.
It's 102 pages.
Oh. That's this.
and on that document, you were on page.
I'm on page 1, the first instance of amendment. So my understanding is that AOE already has $60,000 left over from the $70,000 appropriation that was made in 2024. We're increasing the amount of the startup grant from 10,000 to 15,000. And now you have 6 Seesaws that need that startup grant. And so you need to kick in an extra 30,000 for all of them to be able to get 15,000. And so what Ways and Means, House Education appropriated 30,000 from the general fund. What Ways and Means did and what passed the House was they made that $30,000 an allowable use of the education transformation money from Act 73. So money that was appropriated last year that's still out there. This is not a new appropriation. It is just clarifying that out of that appropriation comes this $30,000.
Yep.
So then we're going to jump back to how H 955 is introduced. And we're going to skip section 5, which is conforming amendments for BOCES to Seesaw. We're going to skip section 6, which is the same, conforming amendments BOCES to Seesaw. We're going to skip section 7, which is the same, section 8, which is the same. No substantive amendments in any of these. We're just substituting Seesaw for BOCES until we get to page 25, section 12.
Can I ask a question? We have till 3:30 to get through these 45 pages.
Well, some of the other, but go ahead.
Did we already, do they have an upper limit on how many staff the Seesaw can hire? No. Okay.
Because it's their money flowing up to the Seesaw.
I can't speak to the policy choice, but
Right.
there's specific language in chapter 10 that says the Seesaw can hire an executive director and any other staff that deems necessary.
Okay.
Section 12, seesaw transition. I'm on page 25, line 16. So within 30 days following the passage of the act, every supervisory union board is required to appoint someone to the board of their new CISA in accordance with what the law spells out for how those appointments are made. And then within 45 days following the passage of this act, the superintendent of the SU with the highest aggregate average daily membership of each CISA has to call the first meeting of the CISA together. And then they're going to elect a chair and other necessary officers, and then they're off to the races. And then on page 26, line 4, subsection C, the Articles of Agreement of the Vermont Learning Collaborative in effect on June 30th, 2026 shall serve as the operating agreement of VTLC unless and until amended. And that language is supposed to just make it clear that the Vermont Learning Collaborative can continue to remain in existence and keep going. They don't have to amend their Articles of Agreement anyway, now that we're changing the Chapter 10. So that's it for the seesaw reader assistance heading. But the concept of a seesaw is going to be important under our next reader assistance heading, which is Union School District Exploration and Formation. And so just to explain what happens under this reader assistance heading is that the Vermont Learning Collaborative is required to hire 8 Union School District facilitators. 1 for each seesaw region, and then 1 lead facilitator who would oversee the other facilitators. They're gonna assign 1 facilitator to each seesaw region. And then that facilitator is gonna group the school districts within the seesaw region onto study committees, which is a concept in current law in chapter 11, our Union School District Formation and Governance chapter in Title 16. And those school districts are going to get together and they have to participate in a study committee. And then we'll go through some of the specific requirements they have to consider. And then what will be, will be. They either decide to form a new union school district or they don't.
Somewhere in here, the Learning Collaboratives facilitator oversees all the other facilitators.
So Learning Collaboratives, your only seesaw that is up and running. So H955 is using VLTC to hire all the facilitators. They hire VLTC or VTLC hires 8 facilitators.
Do you know the reasoning behind that?
The reasoning behind what?
That they have the VLC doing the hiring?
I think that's a policy question for your colleagues in the House.
Thank you. But I figured, but
So that was a very high level overview. So starting on section 13, line 8, subsection A of this section requires VTLC on or before October 1st, 2026 to employ or contract for the services of 7 union school district facilitators who would then be responsible for organizing and facilitating study committees to study the advisability of forming a unified union school district. VTLC is also required to hire 1 lead facilitator who will oversee the work of the 7 facilitators. A facilitator shall have knowledge of and experience working in Vermont's public education system. And then VTLC assigns 1 facilitator to each seesaw membership region. And then we keep going.
You use, I know you use your terms very specific and purposeful. Why in forming a unified union school district? I know you've schooled us several times on unified unions and such. What's the nuance here? Why a unified union school?
I can't speak to why, that's a policy question for your colleagues in the House, but a unified union school district is a school district that is made up of 2 or more towns that's organized to provide for the education of its resident students in grades pre-K through 12. Subsection B. So the facilitators are hired and then they are assigned each CSAW. So on or before December 1st, 2026, two things need to happen. The first is that each facilitator has to assign or group school districts within the facilitator's assigned region to form study committees to study the advisability of forming a unified union school district. The facilitator is required to consult with school district boards prior to finalizing the study committee membership. The facilitator is also required to use suggested school district groupings, that we'll walk through or I'll point out in section 14 as guidance. So there's two maps. There's the seesaw regions and then there's the section 14 guidance map. And then the facilitator shall group school districts together according to the following criteria. So, total average daily membership of the school districts forming a study committee shall be a minimum of 2,000 students as practical. School districts forming the study committee shall be contiguous, and school districts on the same study committee may be members of different supervisory units. And the second thing that needs to happen on or before December 1st, 2026, on page 27, line 15, is that each study committee is required to hold its first meeting.
Can I ask a question? And I'm trying to skip ahead, so I just want to make sure I understand. Okay, so this isn't paid for out of the 15,000 per CISA.
No, that's a startup cost.
Okay, this is 210,000 from the general fund, and it may have changed in the.
I would, absent skipping to those sections and verifying it, I would have to look at the
But there's
language.
money appropriated
Yes.
for this.
Yes.
It's not, they have to come up with their own money.
So notwithstanding, I'm on page 27, line 16, notwithstanding any provision of law to the contrary, a school district is required, so shall participate in the study committee it is assigned to by the facilitator. Then line 19, the study committee formed pursuant to this section shall adhere to the processes and requirements of chapter 11, subchapter 2, which is your union school district formation chapter and subchapter in Title 16. So current law, the current law process. And then everything under subdivision 3 with some slight modifications of that current law.
So current law would require school boards to be involved in, or towns even, to be agreeing on formation of these.
Yes.
And then again, I'm gonna, because I don't fully understand it, on the bottom of page 27, line 21, and it says the study committee, blah, 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 may identify necessary advisable school districts. Seems that this is all about BOCES still, right?
No, we're talking about forming school district,
Oh,
right?
That starts with section.
okay,
13.
okay, got it, sorry.
Yep.
Psychologically, you make the time.
Yep. So on lines 21 and 22, a study committee formed pursuant to this section, meaning section 13 in the bill, may identify necessary or advisable school districts that are not already members of their study committee or are not members of the CSA or both. And then they would work with the applicable facilitator or facilitators to adjust study committee membership if necessary. So facilitators are required to follow certain guidance that you put up here in subdivision 1A. But if the result of that is that once the study committee starts going, they recognize actually it makes more sense for this guy over here to be on this study committee, the facilitators can make that happen. There can be adjustments after the initial.
Facilitators of the CISA.
The facilitators are just hired by the CSAs. The facilitators are facilitating union school district study committees. The CSA is the employer.
Yeah, so what we have is the seesaws get formed legislatively. and then they oversee the work of trying to merge districts of the,
Okay.
the tribe. And that's the concept.
But the entity holding the contract for all those facilitators remains the Learning Collaborative
Yes,
throughout the whole thing.
yes. That's a policy choice you can ask your.
No, I'm not like, I'm not trying to look at you for more answers. I'm just staring out.
So budgets. So under current law, which is 16 BSA 706 and 707, study committees have to form a budget if they were voluntarily forming out in the. And by the way, this study committee process is what the school districts in your bill would be using, right? When they're getting together and talking about merging, they're going to be using this same study committee process, current law. So current law requires them to set a budget, and if the budget is over $50,000, then they have to go to their voters.
Where
Page 28, line 4. So under current law, when a study committee is formed, it has to come up with a budget, and if the budget is more than $50,000, they have to go to their voters for approval for that budget. Spoiler alert. In the Ways and Means Amendment, part of one of their instances of amendment raises that $50,000 threshold to $500,000. But what subdivision B here is doing on page 28, line 4 is saying that notwithstanding current law related to study committee budgets, the study committee formed pursuant to the section shall be funded through appropriations made by the General Assembly for this purpose. Provided, however, that if a study committee's needs exceed the appropriations provided, it may elect to increase its budget according to the processes and procedures established in Chapter 11. So we're going to give you money, and if that's not enough, then go back to current law for getting more money. So we're on page 28, line 11. In addition to the requirements of Chapter 11, the study committee shall also explore the advisability and feasibility of a contemplated new unified union school district operating a regional middle or high school or both. A regional middle or high school contemplated pursuant to this section shall offer resident students increased educational opportunities and access to CTE. So this is just a consideration for them to discuss. So now there's two options under current law. I mean, just in the universe of possibilities, but under current law, there's kind of two options contemplated. The study committee gets together and it makes one of two determinations. It either determines that forming a new union school district is advisable, meaning we want to form the new union school district, or that forming a new union school district is inadvisable, meaning we're not going to recommend that. And so subdivision D, what we're about to walk through, is only applicable if a study committee determines that it is advisable to propose formation of a new unified union school district. They want to make a new unified union school district. Current law,
If I can, just before we gloss over it, same page, line 15. The shall offer resident students, blah, 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 and access to career technical education. What if they don't have a CTE in their region and it's just, there isn't one that's accessible? The shall seems to indicate that.
this is just a consideration for them. So if we go back up to line 12, a study committee shall also explore the advisability and feasibility of a contemplated new school district containing a regional middle or high school. And then I would say lines 14 through 16 kind of define what a regional middle or high school is. So it may be that it's not feasible for that school district. Okay, so subdivision D is only, we're really talking about study committees that have decided to form a new school district. So current law requires such study committees to issue a report. And so we're saying here on line 19, in addition to the reporting requirements in current law, your final report pursuant to this section needs to include an analysis of the following. The educational advantages and disadvantages likely to result from the formation of the proposed unified union school district. I'm on page 29. The financial advantages and disadvantages likely to result from the formation of the proposed unified union school district. The likely operational and financial viability and sustainability of the proposed new unified union school district. And any other advantages or disadvantages of formation of the proposed unified union school district, including any advantages or disadvantages to the students and taxpayers of the region and the state. So the report has to contain that analysis. And then on page 29, line 8, if a study committee determines that it's inadvisable, they also have to issue a report before they dissolve. And this is what the inadvisable report needs to contain. So starting on line 13, the name of the school districts participating in the study committee and whether the participation was formal or informal, an analysis of the strengths and challenges of the current structures of all necessary and advisable school districts, the reasons why formation of a new unified union school district would be inadvisable, with specific references to any state law or rule the study committee found to be an impediment to the formation of a unified union school district, with a specific analysis of why such rule or law was an impediment. And if the decision was not unanimous, an analysis of the minority view of the committee outlining the ways in which a unified union school district promotes the policy of Chapter 11 of Title 16. And then the study committee would transmit its report to the school boards of each of its participating school districts and the facilitator or facilitators that were working with them. And then on page 30, line 9, remember, we're still under the subdivision. We're talking about study committees that have determined it's inadvisable to propose formation of a new unified union school district. Line 9, little triple I there. I still don't know what those are called. Romanet.
That's what Eric puts back.
Okay. Analysis. Okay.
My copy.
Romanet. This is basically saying if you're assigned to a study committee pursuant to the section and you determine it's inadvisable, then you can go on to make any sort of studies you want outside of what's required here.
What's the time period?
There is a timeline. And so if we jump, that's a great segue to line 15 on the same page. They have until December 1st, 2027 to complete their final reports. And if you remember back to the beginning of this section, they were supposed to hold their first meeting by December 1st of 26. So they have a year for the study committee to finish its work. And then the rest of this section is about if they determined that it was advisable to form a union school district, what's the rest of the process?
So now that I see their work product, I'm going back to page 27 to how they are formed. And I think it's a question. I'm trying to make sure I understand. The facilitator is hired by the One Learning Collaborative. They show up in the CISA.
Who's they?
We're not,
The facilitator.
this is on this.
But it says each facilitator shall group school districts within the facilitator's assigned CISA
Region.
region.
Yeah.
So they show up in the CISA region.
Yep.
They get the supervisory unions together.
The member region. So let's read that language together. So within the facilitators assigned CISA region member supervisory unions. So
Yeah,
the school districts within the supervisory unions that make up the CISA that the facilitator is assigned to.
So they get all the school districts together.
And they form study committees according to the rest of the language. You have to read it all together for it to.
No, I'm trying to read it. I'm trying to read it all together. So I'm just trying to be this facilitator because this sounds really hard to do. So they show up in a certain bucket of school districts with a certain bucket of school districts that relate to the supervisory unions and the CISA.
Correct.
That they have some power to make all of those school districts meet for a year.
So let's look at line 6,
Okay.
right? The facilitator shall, so first step, consult with the school district boards.
Mm-hmm.
Who of you out in the community are already talking? Then facilitator looks to the suggested school district groupings contained in section 14 that we haven't gotten to yet as guidance. Then the facilitator uses the conversations with the school district, the guidance from section 14, and puts school districts on study committees together that meet the criteria on lines 10 through 14.
Those are different study committees.
Yes,
They're saying they might have 5 study committees.
they might have 5, they might have 1, they might have 2, depending on
Okay.
how all of the things the facilitator is supposed to take into consideration when making those study committees
And they need to have their first meeting before December 1st, 2026.
on a report card.
Okay.
Just theoretically, these, seesaw districts are coming together and they're looking for, kind of like bonding. If they don't bond, they dissolve, they write a report, and a different group may come together, bond. They may be successful or unsuccessful, but in the iterations that they're all producing reports on pros and cons and the experience and what have you.
Correct.
Till the very end, and then the whistle blows and everybody's in one seat or another.
I'm not quite sure I understand
Well,
that
you
question.
know, they either try whatever it is, 2028 or whatever.
There's a,
They-
there's a final report back to you all with kind of the activity that happened pursuant to this section on, by January of 2029.
But then there's a cleanup part at the bottom of 27 that says if your study committee has 2 districts and they say, you know, so-and-so should really be here, they just didn't get the memo, they can invite that school district.
The language specifically says they shall work with the applicable facilitator to adjust study committee membership as necessary. So they're still working with the facilitator.
To say like, you should come to this meeting.
Yeah.
But if they don't, they're not required to be part of any study.
They are required to participate in a study committee, right? It says that right on page 27, line 16.
Senator Weeks.
Is there a option here for someone who's in a different seesaw to be attracted into a adjacent seesaw?
Yes,
That's
it not, this language does not adjust seesaw membership at all. But I hear you on using the seesaw boundaries as kind of the catchment area, right? Because we're supposed to be.
Right.
So it's not that you could adjust seesaw membership, but yes, if you look at page 28, lines 1 and 2, this is where if a study committee gets up and running and they identify that, hey, maybe someone's missing, they could work with the facilitator to bring someone new to the table. And those new people do not have to be members of the seesaw.
So I don't know exactly where we are right now, but I'll just put a pin in page 28, line 16-ish. I have a really big problem with us getting this far and CTEs not being invited to the table in any way. And then saying these study committees are supposed to figure out what makes sense for career technical education. Am I understanding that correctly?
No, this is about the language here on line 16 is about, as part of subdivision C, it requires these study committees to contemplate whether it's feasible to have a regional or middle high school. And then the language on lines 14 through 16 describes what a regional or middle high school should be, because that is not a concept that is defined in state law. And because CTE centers are not school districts, in the same, as a municipality, right? We're talking about school districts getting together and forming new school districts. And so all of the CTE centers that are being operated by the public schools would be represented by their school boards or their whoever the member is on the study committee for wherever that CTE center is located. But chapter 11 is only about school district governance for the municipalities that hold the taxing capacity.
I think I understand that. I don't have a big problem with it.
I just want to remind everyone that I'm nonpartisan staff.
No, I'm
And I-
saying it for, I'm sorry, I hope you don't feel.
I do. I feel like this meeting has been slightly hostile to staff. And I just want to remind everyone that I am nonpartisan staff and I am just here walking through this bill and you have not heard from the sponsors of the bill yet.
Right,
Okay. Glad we're all on the same page.
I apologize. It felt like that was directed at you.
Thank you. Okay, so we are. Okay, so we're on page 30. And just highlighting that language on line 9. So theoretically, it could be assigned to a study committee. You could know right from the get-go that you don't want to be a part of this. They could write a report in a week and dissolve. Like that is a theoretical, and then they could decide to get together and do whatever they want on the side. And they could do that under current law without any special language what is it? Romanet?
Yeah.
Romanet 3 is telling you, reminding you that that's an option. So, study committee reports due on or before December 1st, 27. And if the study committee has determined that it is advisable currently to form a union school district, current law also requires them in addition to that final report to come up with some proposed articles of agreement. So the study committees have to send the final report and the proposed articles of agreement to each school board that was participating on their study committee. And then on page 31, line 1, subdivision 5, the school board is already required under current law to well, they're not required. They're given the opportunity to review a study committee's report. And they can give feedback to the study committee. And so we're putting H 955 as passed by the House is putting a time limit on that. Current law doesn't give anyone a time limit, but section 13 is saying school boards, you have until February 1st, 2028 to complete your review. And so this is all following current law, right? You get study committee forms, they make a final determination. If the final determination is to form a new school district, the first stop is going to the school boards that were participating to review the report and the proposed articles of agreement. The next stop is to the Secretary of Education. I'm on page 31, line 5. If a study committee determines that it is advisable to propose formation of a new unified union school district, the study committee is required to transmit the required report and proposed articles of agreement to the secretary. That's all current law. We've built in another timeline here. So if the secretary fails to submit the report and the proposed articles along with the secretary's recommendations to the state board within 60 days following receipt of the report, or on or before April 1st, 2028, whichever date occurs first, then the study committee doesn't need to wait for the secretary's recommendation. They can transmit the report and proposed articles of agreement directly to the state board, which is the next stop. And then the state board can take action that it's required to take under current law, regardless of whether the secretary has submitted the recommendation to them. And so I'm on page 31, line 17. The next stop is that the state board is required to issue findings. And we're referring to current law here, so we're not asking the state board to do anything differently than what's required under current law, but we are saying that they have to do that on or before June 1st, 2028. And the next,
Yes, Senator Sheen.
I have a question about timelines. So the BOCES or the seesaws have to be created by June 30th, 2026.
the seesaws, the boundaries are up and running, with the effective date of July 1, 2026.
And the list of services that they may provide. I'm looking at back at page 13,
Mhm.
The professional development all the way to the transportation.
Mhm.
Those have to be developed by when?
There's no timeline for when the seesaw needs to begin offering services.
But and then the studies have to be done by February 1, 2028.
The studies to whether or not to form a unified union school district.
Right. So, okay, so thank you. I think, so I guess just for the committee, one of my concerns here is if we're having these, we're forming the seesaws, there's no timeline for when the services have to be in existence. And so it kind of leaves these study committees kind of almost in this limbo state of not knowing what they can access on the seesaw. You get what I'm getting at?
Yeah.
So I just think it's problematic, but.
Yeah, and I've been not wanting to go too deep into the weeds here because the first question for us is going to be whether we're interested.
Right.
And so we have there's other approaches. This is one. If we get interested, then we probably won't really understand it. But I just wanted to do a high level to give us a sense of what's in here and what we're interested in and what we're not. So, but yeah, I actually I saw that or had noted your question.
I think the seesaws, the only thing seesaws have to do with the study committee process is that you already have one in existence. And so they're going to hold a contract for facilitators.
How many years?
Would the contract be good for? The legislation doesn't specify how long the contract term needs to be.
But it does set a specific amount of money that facilitator would get, and somewhere in here there was, if they want to keep going, they have to pay for it themselves.
It sets an amount of money that the state is appropriating to the study committee, not the facilitator. And if the study committee needs more money than has been appropriated to them, they could then revert back to current law and tap into their own reserves or budgets or whatever.
Okay, so there's an appropriation for the facilitator,
To hire the facilitator, yes.
and that has a timeline.
The appropriation has a timeline?
Is it like a one-time appropriation for facilitator?
Yes.
So then it would be up to the study committees individually to decide if they wanted to keep that facilitator or put their own money together to keep studying.
I believe the way this is contemplated is that the facilitator is going to be contracted for as long as it takes to complete this process. And so would be available to the study committees for the entire time they are required to be doing their work. But the budget is for any of the other work that needs to go into forming a union school district. Like, do you need to hire an expert for financial modeling? Or I don't know I'm not in the field, so I don't know what a study committee budget, what goes into that. But there's I think a $10,000 appropriation going to each study committee. That's for the seesaw. Yep. So 10,000 for a study committee budget. We're giving them the facilitator, which is a cost in and of itself. And so between the facilitator and the 10 grand, if a study committee still needs more, then they can revert to current law and how a study committee would fund itself without these state appropriations.
Okay. Somewhere in there, I'm still not clear like how much the facilitator gets paid.
It's not explicitly stated what the contract terms would be. There is
Okay.
an appropriation that contemplates $50,000 for each facilitator and 60 for the lead facilitator.
Okay, so don't think that's enough money if we do this, but also wondering if halfway through they're like, this isn't the person to get us there, we need someone local or something, I don't know. They just could choose a new facilitator and talk to the originating contract holder,
Who's they?
the study committee.
No.
Let's keep going.
Okay.
That's way down in the weeds. I really want to understand what's in here.
I hear you, I just feel like the house is gonna wanna know if we just say, we don't like it. I'm gonna have a seat.
If we can stick that on the board.
Yep.
Okay, so
So the next stop is a vote. So if a study committee, I'm on page 31, line 19, if a study committee formed pursuant to this section determines that it is advisable to propose formation of a new unified union school district, the voters of each school district that is identified as necessary or advisable shall vote whether to form the proposed union school district in accordance with current law on or before November 7th, 2028. So this is all a current law requirement for forming a unified union school district. All we're doing here is saying that those votes need to occur before election day 28. Or on election day 28. And that is the whole union school district study committee process. The rest of what's in, so subsection F is a status report. So you're asking AOE, this bill is asking AOE on or before February of next year, in consultation with the facilitators, to submit a written report to the education committees and the money committees with information regarding the membership and status of each study committee formed pursuant to this section.
Current law says they have to vote, if they wanted to combine make the new, unified school system.
Yep.
Can the legislative say, we just, if they came back and said, no, if legislation say, you're coming to?
Yes, but it would, you, as if you can remember back to, Tucker and myself, actually, that was for a different presentation, but yes, Dillon, you are a Dillon's rule state. It is your legislative authority to create municipalities. You would need a million more words to actually make it operational than to just put a line in there that says, right?
I get that.
Then it's 2028. 2020.
So we're out of section 13. We're still under the same reader assistance heading, which is the Union School District Formation reader assistance heading, but now we're in a new section. This language represents them on page 32, line 9. This language represents the second map that you should be getting from House Education. And that is the guidance for study committee groupings. So facilitators are required to use these groups as guidance when they're setting their study committee membership. And if a facilitator decides to make decisions that are different from this guidance, that's okay. They just need to explain their choices to the lead facilitator so that the lead facilitator can include it in the final report back to you all in 2029. And then, so there's 21 groups here, and they're all school district groupings.
move on.
Okay. So that will take us to section 15 on page 35. And I didn't, Ways and Means made a few additions in section 13 that we just walked through related to study committees. So I'm going to jump over to that before I forget. So we're looking at the 102 page amendment here, and we're on page 1, line 14, the second instance of amendment. So one of the things that the facilitators are required to consider is grand list values, accounting for the homestead exemption and current education spending when they're forming their study committees.
So that is
And then in the third instance of amendment on page 1, line 18, just adding a requirement that facilitators are required to monitor your work related to education transformation and share the most up-to-date fiscal modeling with study committees. And those are the only changes they made to the Union School District formation process. So section 15 is requiring on page 36, line 1. On or before January 1st, 2029, that lead facilitator is required to give you all a final report with the results of each study committee and whether and information regarding whether and if so how the following issues are influenced the final outcome of each study committee overseen by the facilitator, along with recommendations for legislative action needed to remove identified barriers to the formation of the new union school districts. So did these topics come up? And how do they come up? So differences in staffing costs, differences in operating structures, geographic and topographic barriers, enrollment patterns and projections, and any other factor the facilitator found to have influenced the final decision of a study committee. And then section 16 on page 36, line 17, the Agency of Education on or before January 1st, 2029, in consultation with the study committees and the State Board of Education, is required to submit a written report to you all with recommendations for supervisory union boundary adjustment and seesaw boundary adjustments to take into account any new union school districts formed pursuant to this act. So were there no union school districts forms and we don't need any adjustments, or were there a bunch that means maybe we should look at some of the bigger structures and whether their boundaries need to change? Section 17, I don't think it's worth going over in the House version because Ways and Means struck it and replaced it with a brand new section 17. So if you go over to the Ways and Means amendments, we'll be looking on page 2, fourth instance of amendment. And these are all the appropriations related to the seesaws and the study committees. So the first and every appropriation in section 17 is education transformation money. So none of these are new appropriations. They are making it clear that the money required for these various grants are an allowable use of the education transformation money that you all appropriated in Act 73. So the first one is a study committee reimbursement grant.
Let's not go into the numbers, because this is all just the amount of money that goes with each one.
Yes, and there's some policy here.
Okay.
So the study committee reimbursement, the study committee, I said that study committees are going to be given a facilitator and more money to do their work. That's in the form of reimbursement. So study committees submit receipts and then they get reimbursed up to $10,000 for their costs. And then without going into the money, there is, can I make sure I understand that?
The $10,000 is for each study committee. So you could have a CISA that decides they have 6 study committees and they would get $60,000.
They would be the study committee could be reimbursed for up to $10,000 depending on the actual costs they have spent. Right? They have to submit an invoice
For their costs in addition to the facilitator.
Correct. They don't have to pay for the facilitator at all.
Okay. They're paying for legal and technical assistance.
I honestly don't know what they'll be paying. That's a great question for the field. Yep.
Okay.
So then subdivision B or subsection B on page 3 is the facilitator appropriation. I won't go into numbers. And then on line 16 on page 3, we're gonna give every seesaw $50,000 towards hiring an executive director. But we're only gonna give 6 of them $50,000 because you already have one that's up and running and has an executive director.
Is this like a match for getting paid by the district?
This is just in addition to any membership fees or fees for services that CISA would collect. This legislation is contemplating, in order to get you up and running, we're gonna give you $50K towards hiring an executive director.
But not contemplating that that's all it would cost. Just like this is money towards hiring.
I mean, I don't know how much an executive director would be paid.
Right.
I read it that way.
It could be a surge committee.
Right. Not a limiting amount of money, like a start amount.
So,
And that's the appropriation. So if you don't want me to go into numbers, that's all there is to say about that section.
Okay.
Do you want, it's 329. Do you want to keep going or do you want to stop?
we're close enough to the 40.
Okay.
Things.
So if we go back to the 45, page 1, the House Education. Actually, we're not gonna look at section 18 in the House Education. We're also gonna look at the Ways and Means Amendment,
It's
the 102 pages.
no, which.
With a fifth instance of amendment,
Yeah.
page 4, line 6, Ways and Means struck this section entirely and replaced it with a new one. These are amendments to section 70 of Act 73, which is the effective date section for Act 73, which is where all the contingencies for the foundation formula live. So please don't ask me what some of these sections are because they're largely finance sections. And if and when you have John and Kirby in to talk about the finance and tax sections, they could give you more detail on what the changes contemplated in the December 1 section were. But for the purposes of our discussion, you can see on line 11 that the House pushed the effective date for section 48, which is related to the December 1 letter, out from July 1, 27 to July 1, 29. Subsection F is the big contingencies for the foundation formula. So you can see that a lot has been struck through on lines 14 through 19. So what the House did is they moved the effective date for the foundation formula. It's still contingently effective. So if the contingencies were met, the foundation formula would take effect on July 1, 2030 instead of July 1, 28. And then they created 3 new contingencies and kept one of the current law contingencies. So current law requires that the new school districts contemplated by Act 73 have assumed responsibility for the education of all resident students. That language has been struck and replaced with subdivision A on line 20, page 4. So school districts have had an opportunity to study the advisability of forming a new unified union school district. And the clerk of each district voting on a proposal to form a unified union school district on or before November 7th, 2028 had certified the results. So this contingency is basically saying school districts had to have had an opportunity to participate in the study committees. What is an opportunity? I think absent an act of nature that would prevent folks from actually getting together, that part is probably going to be met, right? But if there is an earthquake that cuts Vermont in half and we can't get everyone together, then I would argue there has perhaps not been an opportunity. So absent some act of nature, that's probably going to be able to happen. So they have an opportunity, and if there is a vote, to the extent that there are any votes that come out of that process, this contingency would be met once those voting results have been certified. So it doesn't depend on specific outcome of those votes. It's just that the vote was certified. On page 5, line 7, subdivision B. This is current law. This is a current contingency in Act 73. The expert tasked with developing a cost factor foundation formula has provided the General Assembly with 45A report. This is JFO's contractor report related to the foundation formula. Subdivision C, on or before December 15th, 29, JFO has provided the General Assembly with an analysis using fiscal year 27 data that compares the total appropriated state funds each school district received under Vermont's existing education formula with those the school district would have received under the foundation formula as it was established in Act 73. And then the fourth contingency is that legislation has been enacted to address the following. Suitable geographic measures for determining sparsity within the foundation formula, whether it costs more to educate a secondary student than an elementary student, and if so, an appropriate weight to capture the cost differential. I'm on page 6 now. How to account for the provision of CTE within Vermont's education formula. How to account for regional differences in operating costs, including those driven by regional differences in cost of living and legacy collective bargaining agreements within the foundation formula. And how to fund special education services, school construction, renovation, and repayment of school district debt, transportation, and universal pre-K. There have been some sections related to finance deleted, and so I'll let either the finance committee deal with those, or I'll have John come. You should have John come speak to you about those. And then the next substantive change I would point out is page 7, line 2, subsection G. These are two set parts of the tuition statute that would only take effect if certain provisions have been met. And the same contingency changes that were applied in subsection F are applied here. So moving the date from July 1, 2028 to July 1, 2030. And then instead of new school districts being operational, you have that there's an opportunity to participate in a study committee. And if there is a vote as a result of that study committee, the results have been certified. And then keeps the rest of the contingencies. And then if we jump back to the as introduced version, we're very close to the end here. We're on page 42 now. Line 8. We're in a new reader assistance heading regarding pre-K. Section 19 is some findings. In the interest of time, I'll let them speak for themselves. Section 20 is legislative intent. In the interest of time, I'll let that language speak for itself. And then section 21 requires JFO on the very bottom of page 43, going on to page 45, requires JFO to I'm sorry, this is another Ways and Means. If you go over to the 102 page one, on page 7, line 18, Ways and Means struck section 21 in the entirety and replaced it with a new section. Keeps some legislative intent. I'm on page 8. Data and reports. It requires the agency, DCF, and Building Bright Futures to establish a system to jointly monitor and evaluate pre-K. And Building Bright Futures is required in consultation with AOE and DCF to report annually to the General Assembly in January. It also requires Building Bright Futures on or before December 1 of this year in consultation with AOE and DCF to submit a written report to you all with the following information. Building Bright Futures has a federal grant right now related to preschool development. And so we're asking BBF to report on their the status of their work under that grant and the data collection that they're doing. What are their initial or updated findings related to student demographics and number of hours by pre-K program by district? Are there any outstanding questions or gaps in data? And any recommendations for legislative action and other consideration? And they're also required to give a progress report to you all on that work on or before October 1st. I'm sorry, to the Joint Fiscal Committee on or before October 1st, 26th.
Senator Williams.
You have a separate bill with notes that says check or go back to the Ways and Means Committee? Remember?
No, I'm doing this all by memory. You will get, it just takes
Okay.
quite a while for the clerk's office and the drafting operations team to put it all
I'm
together.
thinking if I go back this weekend and read it, I wouldn't go back.
I'm not quite sure that, it'll be ready for this weekend. Yeah. And then on page 9, line 19, JFO is required to contract with a contractor with expertise in Vermont's education funding system to conduct an updated cost of care analysis to account for the provision of pre-K within the education finance system. The contractor is required to utilize the results of some recent cost modeling studies that are spelled out. And the study shall provide estimates for the current cost of providing pre-K for children 3, 4, and 5 years old, not yet eligible for enroll in kindergarten. And there is a $75,000 appropriation from the general fund to JFO for this work. And then JFO is separately required to report back to you all regarding different funding mechanisms that may be used to distribute funds for education costs within the new financing formula, including grants, inclusion within the education opportunity payment itself, and different forms of categorical aid. And that is all that the House did. The effective date of the entire H 955 as introduced is a beautiful just July 1, 2026. And that is not what you will be getting when the Ways and Means Amendment is, when everything is rectified. Yeah.
And do you, just for future references, we think about scheduling, do you have sections in,
I do.
that's what I thought you said, yeah. And just so I know, we know which
Section?
Yeah.
So I have the 7th instance of amendment, which is on page 11. And then for the 8th instance of amendment, I am responsible for sections 22 through 22 through 29A, 22 through 29A, which ends on page 29. And then there's also another floor amendment that will get wrapped up in there that John and I both share.
This one?
Yes,
And these are the only things that passed.
only amendments floor amendment. Yep. Okay.
So,
I said, this is right in this one.
I know I have it.
But we'll have it
Balanced. Do I see it's on AM?
It is, sir.
Yeah.
Can you help me out just for a sec, Beth? So, going back to the, Ways and Means Amendment on page 10, the whole study about, providing care or education for children 3, 4, and 5. Can you help me remember the daycare, payroll tax that we created was to affect which ages?
Oh, I don't know. I can find that out for you, but that was a Katie McClin.
So Katie has all the pre-K sections of the bill.
No, I have the pre-K sections of the bill. The work on Act 76 related to the child income, that was not me, but I can get that information for you.
I just want to try to get a differentiation between, pre-K and daycare and what's being proposed here.
Yeah, so what this, I might be able to help clarify that. I can't answer your question specifically about that, but pre-K, this is asking, so pre-K education is defined in statute in section 829 as pre-kindergarten education for children 3, 4, and 5 years of age not eligible to enroll in kindergarten, and that's provided according to like the rules. Those children are also going to be eligible for daycare and CCFAP depending on their family's financial circumstances. So there's quite a bit of overlap there.
And it's a mixed delivery system.
It is a mixed delivery system, right? So right now, the state pays for 10 hours of pre-K.
Thank you.
Do you still want me to check in with Katie on that?
If we decide to keep this section, it would be prudent to get, 5 minutes of differentiation. What we've already done, what we're studying.
We might just want to get Katie out and go that direction.
Yeah, you might not need Katie necessarily if it's more of a question related to what we've done and what this is asking for, because this is asking for JFO to do something. So I think they would be able to speak to what was done in Act 76 from a fiscal perspective and what we're asking them to study and recommend for you all.
Do we have a fiscal note for this bill on the committee
I don't think
page?
so. The bill just passed.
There is a fiscal note.
Yeah.
There's a fiscal note.
Can you put that on our page, Stephanie, or email it to us? Something.
Thank you. We'll finish. We'll figure out the schedule.
Okay.
Are you asking to hear the second part with finance or just separately? I mean, this whole 102-page thing.
Yeah,
is-
well, I think we want our own,
Yeah,
we want our own run through, probably John and Julie in some fashion. So,
I think it depends on where you are, or if there is any lines being drawn between the work that your committee would be responsible for and the work finance would be
Yeah,
responsible for.
yeah, we need to have baselines, even though yeah, that's what the baseline for us. And, you know,
You want Kirby for any of the tax pieces, like the regional, the whatever RAD stands for. Assessment districts, regional assessment districts,
yeah, we'll need to,
appraisal.
we'll need who we need, so it's a combination of
John Kirby.
Kirby
And me,
and, okay.
for Ledge Council.
For your- Yeah, sections, okay.
Yep.
Next.
Okay.
Okay, so we can adjourn for the day.